Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with estates and the questions that you as a real estate agent really need to ask if you are selling a property that is being sold by an estate. So there are several issues that have to be thought through. Number one, Georgia is a probate state, and what that means is that even if somebody dies with a will in the state of Georgia, the estate typically, under most circumstances, has to go through probate in order for the estate to have to be able to deal with the assets of the estate, including real property. So in the case of a house, for example, one of the exceptions to this rule is if it is a couple that has title to the house with joint tenants with right of survivorship, then it may not have to go through probate if the person that passed away had joint title with right of survivorship to the surviving spouse, and the surviving spouse is the person with whom you are dealing to sign the listing paperwork and the contracts to sell the house. So that might be a situation where the estate will not have to go through probate, at least to divest itself of the real property. Of the other assets, it will probably have to go through probate. But in other situations where the heirs of an estate are children or a brother or a sister or some other heir of the estate that isn't a spouse, or even if it is a spouse, but the spouse was not on title to the property and not on title with right of survivorship, more than likely, there are all kinds of situations, and definitely the owners will have to check with an attorney before proceeding. But in general, for you as a real estate agent, you need to be asking yourself these questions. More than likely, the estate will have to go through probate before the person with whom you are dealing can sell that house, can sell that real property out of the estate. Number one, you need to find out if the person with whom you are dealing does in fact have the signing authority to sell off the house. Now, just because a person is named in somebody's will does not necessarily mean that they have the authority to do anything to deal with the assets of the estate. Number one, it depends on the form of probate. There's common form of probate and there's solemn form of probate, and there's different ways of advertising those to determine if there are any other heirs or anyone that is contesting the will, number one. Number two, the estate may have some outstanding debts, and therefore by selling the house, the proceeds of that sale may not go to the heirs of the estate, but may go to somebody else that has a financial claim against that estate. So there's all sorts of issues regarding selling a property when you are dealing with an estate. But again, the questions that you need to ask are, number one, has the estate gone through probate? Number two, the person with whom you are dealing, are they in fact not only just an heir, but are they in fact the executor of the estate or an administrator of the estate? And if so, has that authority been deemed by the county in which the person died through the probate court of that county, or do they just think that because that's what that person had always told them? Again, there may be, even if that person is named in the will, a will in and of itself does not necessarily give somebody the right to the authority, the legal authority to sell that property. And again, especially if it's not a spouse, or if the spouse is not on title to that property with right of survivorship, you could be opening up a whole can of worms if the estate has not gone through the proper legal process before they're in a position to actually sell off that asset of the estate. So again, some of the basic questions you need to ask the person with whom you are dealing: has the estate been through probate? Number two, you really need to request some documentation from that county, either assigning that person as the executor or executrix of the will of the estate, or as the administrator of the estate. Because even if somebody is named in the will, that person, the county may not, the probate court may not deem that person to have the ability to carry out their duties as executor of the will, or again, there could be some contest to the will. So the court could in fact assign an administrator to the estate, and that would be the person with whom you would have to deal with to sign the documents to list the property and to sell the property, regardless, even if that person isn't ever really even related to the person that passed away. Just one other thing to keep in mind. If you are dealing with somebody and they had power of attorney for the person that passed away, let's say you have a person that's on title of the house, that person passed away, the person with whom you are dealing had power of attorney for the person who was on title and who passed away. Once that person passes away, there is no more power of attorney. So you could have been in the middle. Let's say you could have initially listed a property with the person, as long as that power of attorney was specific to dealing with this particular property. But then if the person passes away before you go under contract or before it closes, you may have some issues. These are some legal questions that you need to talk with the person with whom you are dealing, and they need to get in touch with an attorney, or definitely at least with the county, the probate court of the county where the person lived. So as a listing agent, make sure that the person, number one, has the legal authority to sign the listing contracts regarding the real property that you're trying to list and sell. And if you're on the selling side of it, you need to ask the listing agent if in fact they have seen the documentation from the probate court or from the county, or what sense of certainty do they have that the person that they are dealing with does have the authority to sell the house. This all kind of needs to be done before you even list the house. If you do go under contract, you need to bring this information to the closing attorney immediately so that the closing attorney can also check with the court records and the title search and make sure that everything is all truly ready to go. Now, a probate process, depending on the county, depending on if there are any claims to any of the assets of the estate, depending on if there are any financial burdens on the estate where the sale of assets would go to pay off other financial expenses, depending on if there are any contests to the will, probate of an estate can take anywhere from a few weeks to several months or longer. So these are all issues you need to know and be aware of when you are selling an estate and to be an informed real estate agent. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.